You're driving across state lines. Legal cash in your car, buying a truck, inheritance money, or you don't trust banks. You've done nothing wrong. Red and blue lights flash behind you. Every day, drivers lose thousands to police without being charged, not arrested, not prosecuted, not convicted, never accused of any crime, just robbed under color of law. Completely legal robbery. The excuse? I suspect this cash is drug-related. 6 words. Your money's gone. Seized, forfeited, funding their department. You're left proving your own innocence. I've analyzed over 400 forfeiture cases. People lost $2,000, $50,000, over $100,000. Seized during routine stops. No drugs found. No charges filed. Money never returned. I'll show you 5 mistakes that trigger seizures, the phrase that makes you a target, and 3 constitutional protections people never invoke. This is educational content only. Consult a licensed attorney for your situation. Mistake 1. Admitting you have cash. Officer pulls you over for following too closely. Asks, "How much cash do you have?" Most people say, "About $8,000, officer." You just painted a target on your money. Why people answer? They believe cooperation helps. They think, "I'm doing nothing wrong." They assume honesty demonstrates innocence. They don't realize admitting to cash is the trigger that starts the forfeiture process. Here's what happens next. Officer writes down the amount. Radios for backup. Another cruiser arrives. Suddenly, this routine stop isn't routine anymore. They're building a seizure case, live, on body cam. Legal reality. Federal law allows seizure if police suspect not prove cash is crime-related. Burden of proof is preponderance, 51% likelihood. That's barely more than a coin flip. Massachusetts is even lower, just probable cause. 20 states use this same low standard. Body cam captures everything. You disclose the amount. That creates suspicious circumstances, large cash, nervous behavior, out-of-state plates, drug corridors like I-40 or I-80 combined. These create probable cause. Officers learn highway interdiction. Cash seizures fund departments. Under equitable sharing, local police give cash to DEA, get 80% back. Direct financial incentive. Correct move. I don't answer questions. Calm, firm, polite. Fifth Amendment protection. Say it exactly like this. I don't answer questions. Officer pushes. Sir, I'm just asking a simple question. You repeat, I don't answer questions. He tries. Are you hiding something? You respond. I'm exercising my Fifth Amendment right. I don't answer questions. If pushed, I'm exercising my Fifth Amendment right. If asked about cooperation, I'm cooperating. I don't answer questions without an attorney. Stay consistent. Don't explain. Don't justify. Why it works. Officers can't compel answers. Rodriguez versus United States. Stops can't be prolonged beyond the traffic violation. Silence isn't probable cause. Salinas versus Texas. Explicitly invoke Fifth Amendment. Bottom line, never volunteer money information. Officers can't search because you won't answer. But admitting to cash gives them ammunition. You protected Fifth Amendment rights during questioning. But Fifth Amendment doesn't prevent vehicle searches where cash might be found. Fourth Amendment operates independently. Mistake 2 is consenting to the search revealing what you avoided disclosing. Mistake 2. Consenting to vehicle search. You refused questions. Officer says, "Mind if I look in your vehicle? Make sure everything's okay?" Mistake. Sure, go ahead. 3 words costing everything. Scenario. You invoked Fifth Amendment. Officer switches tactics. Asks to search. Tone friendly, casual. Just checking for safety. Here's the exact dialogue you'll hear. I appreciate you being cooperative. Mind if I take a quick peek inside? Make sure there's no weapons or anything dangerous? Just for my safety and yours. Sounds reasonable. It's calculated. People consent now. Refusing looks suspicious. They think innocence will show. They don't realize. No presumption of innocence for property. What happens? Officer searches, finds cash, $3,000 or $30,000, calls drug dog. Dog alerts. Happens 90% because currency has cocaine traces. Seizes cash claiming dog plus cash equals probable cause. Body cam problem. You consented. Recorded. Prosecutors argue you allowed it. No Fourth Amendment claim. Consent waived protection. Officers train for consent through psychology. Make requests seem routine. You don't mind, right? Nothing to hide. Designed to make refusal awkward. Desert snow teaches consent beats probable cause. Correct response. I do not consent to searches. Clear. No explanation, no justification. Officer. If nothing to hide, why not? Answer. I do not consent to searches. Am I free to leave? He continues. You're acting suspicious now. You repeat. I do not consent to searches. Am I being detained or am I free to leave? Officer. I'll get a warrant. Response. Then you should do that. I do not consent. He might wait for the dog. You stay calm. You stay silent. You don't consent. Your refusal will frustrate the officer. He might become aggressive in tone. Stand firm. The Supreme Court has your back. Why this matters. Refusing preserves Fourth Amendment. Pennsylvania versus Mims allows exit orders for safety, not search authority. Without consent or probable cause, no search. Refusal isn't probable cause. Florida versus Bostick confirmed. Marijuana smell claims probable cause separately. But in legal states, Colorado, Washington, Maryland, smell alone may not work. Courts limited smell searches in legalized jurisdictions. Critical distinction: request versus order. Can I search? Is a request. Decline. Step out is an order. Comply. But ask first, are you asking or ordering? If request, decline. If order, what's the lawful basis? Then complying under protest. Bottom line, never consent. Officers need probable cause or warrant. Refusal isn't probable cause. Stay calm, firm. I do not consent to searches. Fifth Amendment protected silence. Fourth Amendment protected against searches. There's a third protection once property's seized. Eighth Amendment's excessive fines clause. Mistake 3 is failing to document what the seizure violates. Mistake 3. Not documenting legitimate source. Benjamin Molina, New Jersey carpenter, drove through Virginia with $18,000 cash, buying a car. Police seized everything. No receipts, no bank records, no documentation. Mistake. Couldn't prove legitimacy. You're stopped. Officer finds cash during a search, maybe drug dog, maybe plain view, cash seized. Receipt given. Notice coming about forfeiture. People think, I'll explain the source. They'll return it. This destroys your case. In civil forfeiture, the case targets property. United States versus $35,000. Texas versus 1 gold crucifix. Property is defendant. You're not entitled to court-appointed attorney. You're not the defendant. Federal law, 18 U.S.C. 983, you prove you're innocent owner. Government shows preponderance that property connects to crime. Once they meet that, you prove innocence. Proof requires documentation. Bank withdrawals matching amounts, casino receipts with dates, employment records, purchase receipts, tax returns showing legitimate income, witness statements, contracts, body cam shows, stop and seizure. Not documentation, you lack. Prosecutors. If money's legitimate, where are records? Lack becomes guilt evidence. Money's guilt. officers won't mention Civil Asset Forfeiture Reform Act 2000 says if you win, government pays attorney fees. People don't know, don't hire attorneys, lose by default. Before traveling with cash, create paper trail, bank withdrawal, one transaction, receipt, inheritance or settlement, official documentation from attorney or executor, buying something, written contract, both signatures, dated, photo cash with newspaper showing date. Email yourself photos for timestamp. During stop if cash discovered, I want an attorney before answering about that cash. Don't explain. Don't say buying truck or inheritance money. Every word on body cam used against you. Invoke fifth. Stay silent. After seizure, 30 to 35 days to file claim. Miss deadline, automatic administrative forfeiture. Government keeps it. No hearing, no appeal. Filing claim. Attach all documentation, bank records, receipts, employment, tax returns, affidavits. You prove property's innocent. Why it works. Innocent owner defense, 18 U.S.C. 983D, requires proving you didn't know property connected to crime. Documentation shows legitimate source. Defeats government's claim. Example, Phil Parhamovich, Wisconsin musician, I-80 stop near Cheyenne. 91,000 seized. Life savings. Had bank records, documentation, Institute for Justice representation, got every penny back. Bottom line, before travel, create paper trail. During stop, say nothing. After seizure, gather documents, file before deadline. Without documentation, uphill battle. Documentation provides civil proceeding evidence. But what if criminal charges are added? That changes everything, triggering different protections. Mistake 4 is not understanding when civil crosses to criminal and why that distinction matters. Mistake 4. Thinking charges are required. Shock. Police seize and keep cash without charging you. Not arrested, not prosecuted, not convicted, never accused. Completely legal. Mistake. Assuming forfeiture requires charges. It doesn't. Traffic stop. Officer finds $5,000. Suspect's drugs. Seizes under civil forfeiture. Warning ticket or no ticket. You leave. No arrest, no charges, no Miranda. You haven't been accused. Why people think charges required? They confuse civil with criminal forfeiture. Criminal forfeiture follows conviction. Judge and jury convicted you, then determine if property connected. Part of sentence. Civil forfeiture's different. Civil forfeiture targets property. In rem jurisdiction, against the thing, not in personam, against person. Based on maritime law, pirate ships, government sues property, United States versus $24,000. Money's the defendant. Legal reality, Washington Post analyzed 400 equitable sharing seizures. 0 arrests, 0 charges, seizures stood. Texas Tribune study, 40% no conviction. Webb County, over half no charges. Harris County, 2/3 under $5,000, half under $3,000. 955 from one man, 2,400 from another, 32,000 from a couple. Traffic stops, small amounts, no prosecution, property forfeited. Without charges, no speedy trial right, no witness confrontation, no court-appointed attorney, no Miranda, no innocence presumption. Burden is preponderance, not reasonable doubt. You prove property innocent. Government doesn't prove you guilty. Officers exploit this. Civil forfeiture beats prosecution. Former federal prosecutor. Forfeiture works when offender unknown. Someone else owns property. Crime too minor for conviction. Translation: criminal case too hard. Civil and criminal interaction. Forfeiture proceeds before, after, or without indictment. Criminal acquittal. Civil forfeiture still succeeds. Different standards. United States versus Usury. No double jeopardy violation. Seizure without charges. Notice within 60 days, 90 if transferred to DEA. 30 to 35 days to file claim. Don't file? Government wins by default through administrative forfeiture. File claim, federal court. Government proves preponderance property substantially connects to crime. Don't prove you committed crime, don't charge crime. Show property more likely than not connected. Cash plus nerves plus drug corridor equals connection. State reforms. New Mexico abolished civil forfeiture 2015. Requires conviction. North Carolina, Nebraska, Maine, same. 16 states total, but loophole. Federal equitable sharing. Local police transfer to federal, who forfeit federally, return 80%. Bypasses state protections. Bottom line, charges unnecessary. Government seizes, keeps, never charges. Recourse. Timely claim. Prove property innocent. Requires documentation. Representation. Often costs more than seized amount. No charges means fewer protections, but one applies to both. Eighth Amendment excessive fines clause. Timms versus Indiana changed this. Mistake 5 is not challenging excessive forfeitures when grossly disproportionate. Mistake 5. Not challenging excessive forfeitures. Tyson Timms sold $4,000 in heroin. Indiana convicted, sentenced home detention, probation, fined $1,200. Then seized his $42,000 Land Rover, 4 times maximum fine. Mistake. Not challenging as Eighth Amendment excessive fine. Cash seized. $10,000, $50,000. Alleged crime involves less, maybe no crime, just suspicion. Amount bears no relationship to harm. You think, they took it legally. Wrong. Constitutional limits exist. Why people miss this? Don't know Timms versus Indiana, unanimous 2019 ruling. Before, states claimed excessive fines clause only applied federally. Court ruled, applies to state and local. Civil forfeiture counts as fine. Gross disproportion violates Constitution. Timms framework, Justice Ginsburg wrote, excessive fines clause carries Magna Carta protections, sanctions proportioned, not depriving livelihood. Risk when fines raise revenue, exactly forfeiture's purpose. Excessiveness test from United States versus Bajikagian. Is forfeiture grossly disproportional to offense gravity? Consider. Harm caused, maximum penalty, owner culpability. Timms case, 4,000 heroin harm, 10,000 maximum fine, 42,000 vehicle. Indiana Supreme Court, grossly disproportional, Eighth Amendment violation. Timms got Land Rover back. Body cam shows stop, discovery, seizure, not proportionality. Pulled over for following closely, 20,000 seized. No relationship. Excessive. Officers won't mention Timms. Limits power. Department's budget forfeiture revenue. St. Louis County bought Bear vehicle with forfeiture. Policing for profit. Challenge succeeds. Money doesn't fund them. Legal strategy. File claim, including Eighth Amendment challenge. Argue gross disproportion. Compare seized amount to alleged offense. Compare to maximum penalty. Show livelihood deprivation, hardship. Vehicle seized. Argue value exceeds maximum fine. 10,000 seized for border currency reporting. Cite Bajikagian. Court ruled seizing all excessive when maximum penalty 5,000. State applications. Florida requires reasonable doubt even for civil forfeiture. North Dakota, clear and convincing. Washington 2025. Reforms clear, cogent, convincing evidence, extended deadlines to 60 and 120 days. Why it works. A tax forfeiture justification. If punishment, Eighth Amendment proportionality applies. If remedial, proportional to harm. Neither? Excessive. Bottom line. Limits exist. Gross disproportion? Challenge under Eighth. Cite Timms. Cite Bajikagian. Show math. Seized versus penalty versus harm. Constitutional argument recovers property. Core principle. Civil forfeiture inverts Constitution. Property guilty until proven innocent. Burdens on you. Police profit directly. 4 phrases protecting you. Am I free to leave? Establishes detention status. I invoke my right to remain silent, or I plead the 5th. Explicit statement required. I want an attorney. Ends interrogation. I do not consent to searches. Preserves 4th Amendment. Next steps. Avoid traveling with large cash. Must create documentation first. Physical copies separate from cash. Digital copies emailed. Traffic stop. Calm, polite, firm. Invoke rights clearly, repeatedly. Never answer cash questions. Never consent to searches. Property seized. 30 to 35 days to file. Calendar it immediately. Gather documentation showing legitimate source. Consult attorney. Many work contingency. Government pays fees if you win. Educational content only, not legal advice. Consult qualified attorney in your state for your situation. Like subscribe. Mikinsawatij, said Shral. Notification bell. Share with everyone needing to protect money from civil asset forfeiture. Other critical phases exist where different legal principles and constitutional protections apply. Situations where these phrases won't work and you need additional case law understanding. That framework builds on what we covered. Showing on screen now. Watch before facing this. Once seizure happens, too late to learn protections. Knowledge is power, but only if you use it.